No actual presentation.
I am the
But there's a handout, a one-page going out. I suppose the season that we're in, I just thought I'd give a shout out to all the kind of Leaving Cert students or whatever. I did the construction studies for Leaving Cert 2005, and actually, in a nostalgic whim, I printed off the paper, which is completely irrelevant to today, but I just thought that's really my technical foundation in construction law. I went through Trinity, King's College London, and then the King's Inns in Dublin with no real contact with construction law, maybe a little bit of environmental law during my undergraduate. It was only after I qualified I worked for a year in London with Practical Law Company. I don't know if there's anyone familiar with that. Hands up if you're familiar with Practical Law Company. Yeah, 2, 3, yeah. For those of you who don't know, I think really the two excellent services that Practical Law Company provide are one, what's called a fast draft. So if you're, I suppose, in-house and you're trying to draft a document, the fast draft service in Practical Law Company is excellent in that you just have to fill in a few questions and you can come up with warranty clauses very quickly. And secondly then, which I'm glad it was just being pioneered in my day, but Ask PLC or Ask Practical Law Company, everyone can hear me I think, yeah, is a tool where essentially if you're a subscriber to the service you can ask Practical Law Company any question. So I think that's excellent. You don't have to be a law firm, you could be, you can subscribe, anybody can subscribe. Your company, if your construction company might consider this subscription worthwhile, you can ask them any question, and that's certainly in London driving down the prices of legal advice in this area. What I've given out is just a 2-scenario kind of, I suppose, case studies really is what they are. Before I go into them though, can I have a show of hands who's practicing? Are there any practitioners? Show of hands if you're practicing. Just over at a half. Anyone in-house? And nobody in-house, and then everybody else just miscellaneous construction studies. Okay, well I suppose hopefully what we'll have is a dialogue on these two scenarios, but just to look at the first one there, it's a penalty clause really is at the heart of it. It's a lateness scenario, and I suppose if you look at first of all the arbitration clause, all disputes arising out of this contract shall be determined by arbitration. So I think the two key words there are rising out of, I suppose being the magic legal words, which is important. Those whatever words you put in there, the formula does have a legal effect. So is it, and you can contrast that with the other scenario, any dispute arising under the contract. They actually mean different things. The penalty warranty clause then in the scenario 1 is that the contractor is unable to claim time and money for adverse weather conditions. So if you're a contractor, you're obliged to assess how long it will take you to complete the project and take into account the likelihood, if you're in Ireland, of very bad weather. And then the second point of the warranty clause that all material delays shall be subject to a liquidated and ascertained damages mechanism. I'm assuming most people will know what that is. Just very quickly, it's a fairly clear table or schedule of, let's say, given the nature of the product, 1 week delay equals this amount of a penalty, and it will be based on the ascertained or the ascertainable loss of the client. So if you have somebody who's hoping to open up a supermarket in time for Christmas, losing out a week or two at Christmas can be crucial. Okay. Then just going down to the evidence section there in scenario 1, that the client had nominated its own employee to be on site throughout the construction process, and amongst other things, the client's employee took a diary of weather. Now, obviously, we can look back and see what the weather was like in Dublin, but to have an on-the-ground, contemporaneous note of the weather in this situation certainly would prove very helpful to the client. And then we saw there, just up above, just at facts there, the contractor is asserting that 6 weeks of the delay were caused by weather, which during which work would have been impractical. I've noted there discovery and inspection. Actually, on the page, it's the only words really that are underlined. I think it's important is discovery and inspection were expressly included under the contract. So if you're negotiating a contract, I think that's important. The Arbitration Act 2010 really, I don't think it's clear. I might be contradicted by a colleague, but I don't think it's clear if you can get discovery as part of the arbitration process. Certainly, if there's a dispute, I'm sure one party will say, if it's not mentioned in the contract, we don't think the arbitrator has authority to order discovery. And so it's important, just those lines, that if you are negotiating contract, it can work either way. And then you have the fruit, let's say, of the discovery and inspection process underlined there at A and B. I think B, for me, just coming up with this, I just imagined, let's say, a group of four, say 4 lads just kind of out on a night out. They showed up to work drunk and they were suspended for 1 day, and then when they came back from just a 1 day suspension, that's when the machine broke. So I suppose you can infer a lot from that, but certainly the disciplinary proceedings there, what were they? What circumstances gave rise to the suspension? Certainly discovery in this situation is really the only way you can get that information. Okay, just going back up there to the diary, my other note was that if it does go to arbitration, obviously the rules of evidence will apply, and really not having the author of the diary might prove problematic. So certainly it's all well and good to have this person on site maintaining a diary, but really its strength or the weight applied to it at arbitration will be much greater if it's backed up by oral evidence. Okay, just a couple of notes on scenario 2 then, and I'll open it to observations from the floor. This is really a time-based problem, but it's also really the operation of warranties. So 8 years after a large building project completed, subsidence caused numerous wall cracks and uneven flooring. 4 years after that, a legal action is contemplated against the contractor. And I've done my own timeline here, and under the contract, arbitration is the appropriate forum only 3 years after completion. So for those of you, I suppose, put a big star on the duration or term of your arbitration clause. When does it cease? When does the arbitration clause in the contract, the operating part of that, when does it cease to apply? Because in this situation, whatever happens, it will proceed by way of normal proceedings, if at all. And then the second point is, we see here 4 years after that, just back up in the facts, we're 2 years shy there of the statute bar. So really he's currently within time, but the action is contemplated. Really, it needs to be issued within a further 2 years of, let's say, today's date, otherwise it would be barred. The idea here that a client conducts some preliminary ground investigative work and furnishes that report to the contractor, I think gives rise to an interesting conflict where, you see in this particular example, the contractor is told nearly, or it's implicitly told, you can rely on this document, which turns out is erroneous. And so I suppose the difficulty there is when you balance that against the fact that in most contracts the contractors assume all risk for ground conditions. I think they're my main notes, and I just thought it'd be an interesting exercise to look at those. Does anybody have any insight or comments on anything I've said? Any questions or anything to add? No? Okay, well, it's been Pleasure. Finished early, yeah.